have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve any time for rebuttal, if you let me know, I'm keeping the clock this morning and can keep you apprised of the passage of time. The court's read the briefs, so ready to proceed when you are.
May it please the court, my name is Todd Hunt. I am the city solicitor for the city of Hudson. I would like to reserve 3 minutes for rebuttal. And today, this court has the opportunity to clarify the law of Ohio regarding extraterritorial water rates and charges by a municipal purveyor and uphold principles of fairness, reasonableness, and a rational basis for those charges. I think it's important just to run through the facts very quickly, and I know you've read the briefs, but the city of Akron supplies water to a portion of the city of Hudson. It's really that area that was formerly Hudson Township prior to the merger of the township and the city of Hudson. Akron serves approximately 1,500 customers in Hudson, including the city of Hudson itself, which has one facility that's in the Akron service area. Other purveyors, of course, are the city of Hudson itself, the city of Cleveland, and also the city of Stowe. Stowe serves approximately 259 customers in Hudson. Akron water flows through the Stowe lines in Hudson.
Does the record reflect the reason for the inception of the water services within Hudson boundaries by the city of Akron?
Yes, it does.
It does? Okay,
Yes.
thank you.
And in November of 2014, Akron unilaterally imposed a surcharge of $17.76 to residences, that's per month, on its customers and on Stowe customers, and a 42% increase in the rates for a surcharge for commercial properties. Akron represented its surcharge to be for the replacement of a transmission line that runs from Lake Rockwell in Portage County through Hudson and up into Twinsburg Township and the city of Twinsburg. And the amended complaint alleges that the surcharge is unnecessary for this transmission line. It's unfair, it's unreasonable, and it does not bear a rational relationship to the water services that are being provided in Hudson. The surcharge is only one of 3 components of the charges that are made by Akron to Hudson customers and Stowe customers in Hudson. And their rates are first 160% of the Akron base rate that it charges to Akron residents. So it's 60% higher than that. And it also has a capital projects charge that's been on the invoices for quite some time. And now the surcharge. So in December of 2014, the city of Hudson filed a complaint, styled as a class action, for declaratory relief to find the surcharge as being unlawful, unfair, unreasonable, and not reasonably related to the services being provided, and a permanent injunction to stop the surcharge, as well as damages for those surcharges that customers have been paying since November of 2014, plus interest. Akron filed a motion to dismiss, as you know, and that was on legal grounds only. The class was not certified yet because the first act that was taken was the motion to dismiss based on legal grounds. The trial court, of course, granted the motion to dismiss, and Hudson appealed the trial court order and its opinion as being fraught with error, and it should be reversed. The standard of review, of course, here is de novo review. These are legal issues that are being presented to the court. You stand in the shoes of the trial court and looking at this dismissal under 12b-6. So the facts that are set forth are accepted as true in the amended complaint, and we're looking at the legal claim and whether it has legal legs, which we certainly assert it does.
Well, as it relates to the claim, in its complaint for declaratory judgment, is the city of Hudson asking the court to decide whether the city of Akron can legally charge the Hudson residents for this, or is it asking the court to decide whether or not the residents of Hudson are legally bound to pay it? Or you may believe that's the same question, I'm just trying to understand what the declaration
I don't
was.
believe it's neither one.
Okay.
What it is that the charge that's being assessed is not reasonable, fair, or rationally based.
So,
I admit that certainly the city of Hudson or the city of Akron can charge a reasonable rate. They can charge for capital improvements, and they're doing that. And then what they did was add on a surcharge on top of that.
and it's my understanding that we are talking about that surcharge. We're not talking about the 160% or the,
Not at this
not
time.
at this moment, I understand, okay.
And maybe pursuant to discovery, we'll discover some other issues related to those other charges. But we understand that Akron, as well as other purveyors, municipal purveyors of water, when they supply water outside their jurisdiction, they bump up their base rate from their residents, their own residents, and bump that up. The putative class here, which, and other customers around the state of Ohio that would be similarly situated with a municipal purveyor, which is extraterritorial customers, not subject to a contract. There's no contract here between the city of Hudson and the city of Akron to provide this water. It's the only group of customers across the state who have no remedy whatsoever to challenge the charges that are made by a municipal purveyor. Private investor public utilities are governed by the PUCO. Their rates are governed by the PUCO. They must be reasonable. According to the trial court in the city of Akron, courts can review the reasonableness of rates of residents of that municipal purveyor. Pursuant to the case law that's been cited in our briefs, there are contracts with municipal purveyors, and that provides for charges, and of course it's a contract issue between the parties as to what can be charged pursuant to that contract. Here, this category of our putative class have no remedy whatsoever with respect to charges. We might as well dive right into fairway manner. Purely and simply, that's a contract case. It was unnecessary for Justice Douglas to get into any kind of a constitutional analysis. I know the city of Akron is trying to argue that, well, they were arguing discrimination in that case, and therefore he had to address it. We're not arguing discrimination, we're arguing the fairness of the charges. The issue presented is, quote, to what extent will a court review the rates charged by a municipally owned public utility to an extraterritorial purchaser when those rates are contained in a contract negotiated between the parties? The syllabus of that case states, municipally owned public utilities have no duty to sell products, including water, to extraterritorial purchasers absent a contractual obligation, number one. And number two, where rates for water for a municipally owned public utility are set forth in a contract, such rates will not be struck down as discriminatory, even where no factor exists which could justify the rate discrimination. And the court goes on to say, to justify that number two of the syllabus, but where a particular rate is fixed by contract, it is for the parties, not the courts, to determine the rate to be charged. In such matters, courts will presume the wisdom of the bargain and uphold the contract. Simple, basic contract law. The holding of fairway manner is instructive at page 90. Accordingly, we hold that where rates for water from a municipally owned public utility are set forth in a contract, such rates will not be struck down as discriminatory, even where no factor exists which could justify the rate discrimination. So it does not deal with extraterritorial customers, it deals with a contract. We admit that Justice Douglas made a statement in there applying the Mount Sinai Hospital case from the Supreme Court, saying that it dealt with customers inside the city of Cleveland. Those are the facts. If you read Mount Sinai, it makes no distinction between intra-territorial customers and extraterritorial customers. There's no difference between customers within a jurisdiction of the purveyor and those outside. Neither have a contract which governs charges, and the municipal purveyor has no duty to supply water inside its municipality, no duty, and no duty outside. We admit that it has no duty outside its territorial limits to provide water. However, the issue is not whether a municipal purveyor has a duty to supply water to extraterritorial customers absent a contract obligation. What the issue is when that municipal purveyor provides water outside its jurisdiction, it has to do so under reasonable circumstances, reasonable charges, fair charges, and reasonably related to the supply or the service that's being provided. Justice Douglas did not have to reach any constitutional issue to decide that case in fair-way manner. It's a contractual case. He went through a constitutional analysis simply to debunk the, at that time it was the Summit County was the adverse party, was making the argument of discriminatory rates between the city of Barberton and other jurisdictions within the county. We are not making that claim. I think instructive too is the Supreme Court's later case of Perrysburg. The Perrysburg case, it's Bakey's versus City of Perrysburg. And fair-way manner was only cited in that case for the proposition that the municipal purveyor of water has no obligation to provide water outside municipal boundaries.
We're just now reaching that 3 minutes. You proceed or reserve it to
And I think it's instructive that the holding in that case was based on one of the pertinent constitutional limitations set forth in page 368 of the Bakey's versus Perrysburg case, is that Akron's operation of a water utility must have a rational relationship to the water services provided. There it was an imposition of annexation requirement. They were imposing contracts on property owners outside the jurisdiction where they were already supplying water, not under a contract. And they then went back and said, we want a contract with every customer and you have to annex to the city of Perrysburg. The court analyzed that under the constitutional test of whether it had a rational relationship to the provision of water service. And of course the court found that it did here, but the significant part of it is that it went that next step and did a constitutional analysis. Here the trial court did not do that, and that is error.
May it please the court, Stephen Funk of Hudson on behalf of the city of Akron. Let me begin by emphasizing that this appeal does involve a legal issue. It does not turn on the factual sufficiency of the complaint. And I agree with my colleague that it doesn't deal with the two issues that you asked about. The only issue that they're actually addressing, the only claim that they're alleging in the complaint, is a very specific claim that they want to challenge the amount of the water rates charged by Akron to extraterritorial customers in Hudson based upon essentially a constitutional standard. And it's clear, and the question before the court is, has Hudson identified a valid legal basis for that claim?
Right, so the first of those two questions were, can Akron legally charge this surcharge?
And that's not before the court.
Okay.
And the question before, what's very clear is that the Ohio Supreme Court has consistently held that the operation of a municipal utility is a home rule power. And so the Ohio General Assembly does not have any power to either require a municipality to furnish water to non-inhabitants or to limit the price that a municipality may charge to a service. That's in both McCann and in Fairway Manor. So the question then becomes, what is the constitutional basis of their claim? Now, in proceedings below, they relied upon the Mount Sinai opinion, and that opinion dealt with water rates charged to the residents of the municipality under Section 4, Article 18 of the Ohio Constitution. The problem with that is that the Supreme Court in Fairway Manor very clearly stated that the constitutional limitations on the rates charged by municipally owned utility is strictly limited to the residents of a municipality and does not apply to extraterritorial customers. Now, that analysis was clearly necessary for that opinion, because what the issue was in Fairway Manor was that the lower courts had found that the rates that were set forth in the contract were unconstitutional, and they applied a constitutional standard to those rates. And they relied upon Western Reserve Steel, which was a predecessor to Mount Sinai, for the proposition that you can't avoid your constitutional duty simply by entering into a contract. So the court had to decide that, in fact, the constitutional standard did not apply to this case because it didn't apply to extraterritorial customers. Then it went on to proceed to explain, throughout the rest of the opinion, essentially the policy reasons for why the courts do not want to get involved in determining the reasonableness of rates in a contract. But the key point for this court is that Fairway Manor sets forth the operative constitutional analysis that answers the question presented in this case. And that the question is, does the limitations of Mount Sinai apply to extraterritorial customers? And the answer to that question, Fairway Manor very clearly states that it does not. And there's no reason why that constitutional analysis would depend on whether or not there's a contract. It's a question of, does it apply to extraterritorial customers? Whether they have a contract, the same question would be the same constitutional analysis would apply. The answer to the question is no, it does not. And the Hudson has tried to argue that that's dicta. First of all, the Supreme Court has amended the rules of reporting of opinions in 2002 to make it clear that the text and body of the opinion is just as much authoritative and binding precedent as the syllabus. And in fact, the Supreme Court in 2006, as was noted, cited Fairway Manor in the Bakey's case, and that was in a unanimous opinion. The important thing about Bakey's is that was a challenge to the exercise of police power. The city of Perrysburg had adopted an annexation requirement that an extraterritorial customer would not get water unless they agreed to be annexed to the city. And the question was, did that exercise of police power violate the Constitution? So they applied a health, safety, and welfare standard for reviewing the exercise of police power. That's not the claim that's been alleged by Hudson in this case. That's not the claim they alleged in this case. They're not challenging police power. The Supreme Court has specifically said that water rates are proprietary capacity. So what they're not relying on Bakey's in order to challenge the water rates in this case, nor could they. They're relying on Mount Sinai. Mount Sinai, though, only applies to residents of municipalities. So the fact of the matter is, if you look at their briefs, both below and in the appellate court, they have not cited a single case that's been decided since 1988 in which the court has held that an extraterritorial customer can challenge the amount of the water rate charged by a municipally owned utility. Not a single case. Now, prior to 1988, there was litigation like this going on all the time. We had 6 years of litigation in Fairway Manor where Summit County was challenging the reasonableness of the water rates. They cite cases from the 1970s, the city of Bedford, the city of Lakewood, where customers outside of Cleveland were challenging the rates charged by Cleveland. All of that was based upon Mount Sinai and Western Reserve Steel. 1988, the Supreme Court says, no, that all does not apply to extraterritorial customers. And since then, we have not seen any of those cases. Now, there's one case from the 8th District, Risco Investments, but in that case, the 8th District actually held that it did not, that resident could not challenge because they were an outside the municipality. So the case law is very clear. Fairway Manor, if you read it, it addresses the issue that's before the court. And the trial court did a very careful analysis and specifically said, The claim that Hudson is alleging in his case, it's been clarified by Fairway Manor, it does not arise as a matter of law. And now, we've pointed all that out in the briefing, it's been extensively briefed, and won't keep going over it. But they do try to attempt some alternative theories in their brief that were not alleged below and that don't stand the case as a matter of law. First, the Amherst Builders case. That case was decided in 1980. That was a challenge to a tap-in fee. This is not a tap-in fee, and no one ever alleged it was a tap-in fee. But the key point is that the Supreme Court in that case made very clear that they were applying a standard under Section 4 of Article 18 of the Ohio Constitution. And the Supreme Court in Fairway Manor then, in 1988, said that that section of the Constitution only applied to the residents of the municipality. So it's clear that Amherst Builders would not apply to extraterritorial customers. Secondly, they cite to the Home Builders Association case. That case had nothing to do with this situation. It involved a takings claim to an impact fee charged by municipalities for commercial development within the municipality. And the court analyzed that on a takings standard. It also involved the exercise of police powers. It did not involve water rates. It didn't involve the amount of water rates involved. And then they also argue that the surcharge is an illegal tax. That case was not, that claim was not alleged in the complaint. It was also meritless as a matter of law because the Supreme Court is very clear that water and sewer charges are not taxes. They are simply a charge by the government for service.
Well, I can understand that there were probably a significant amount of briefing regarding this motion to dismiss. The court stated that Hudson failed to state a claim upon which relief could be granted. There's a lot of legal argument about perhaps what can and can't happen. And you are indicating they didn't make these other arguments below in terms of tap-in fees and proprietary functions being just like a private water supplier. Does that mean that the court never addressed those other avenues before it dismissed the complaint for failure to state a claim?
Well, I think that if you want to say that the court addressed every case that they cited in their brief, I would say no, that she didn't do that. What she did do is she focused on what are the cases that address the legal issues that's before the court. And they did make a very narrow, specific claim. The remedy that they sought a very specific remedy. They wanted to continue water service with Akron. So they're not challenging any termination of water or anything like that. All they want to do is they want to continue the water service, but they want to have the court intervene in order to challenge the amount of the rate. And on that question, the court dealt with what is the case law before me that addresses that issue. And she found that looking at their brief and looking at the Supreme Court's opinion in Fairway Manor, that Hudson had failed to identify a valid basis for their claim. Now, on courts, this court has de novo review. It can look at all the cases cited in the briefs. Of course, you have to also apply the rules relating to, not have to, but there's also rules relating to not raising new arguments on appeal and things like that. But I don't think that if the argument is she didn't consider Amherst Builders, therefore that's reversible error, I don't think that would be the case.
Well, right, I guess
Because it doesn't apply.
this is strictly a declaratory judgment complaint, correct?
They also are seeking an injunction and they're seeking a damages, but all three relate to the same issue. The very specific narrow remedy to challenge the amount of the claim, that violates, that's unreasonable and unfair. And on that issue, that's the question. What is the law? What law do we look at to govern, does that state a claim? And on that issue, Fairway Manor provides this court and the trial court with the operative analysis, the constitutional analysis, and answers the question, does that challenge apply to extraterritorial customers? And the answer to that is, no, it does not.
But dismissing a declaratory judgment on the basis that it's failure to state a claim would also, I think, probably inherently mean that it's not a justiciable issue? To get to your finality, I'm going to go into the finality issue.
Right. The specific declaratory judgment, that they weren't asking for, declare all the rights of all the parties. They were very specific and very narrow. They were asking for, we want you to declare that the surcharge is unjust, unreasonable, and not rational in relation to the service being provided. That's the claim that they alleged. And the court said, I'm without, essentially, under Fairway Manor, I cannot make that declaration, so therefore that declaration fails to state a claim. That request for that declaration fails to state a claim. So, and that's really the question before the court. When you look at all the briefing, has Hudson identified a valid legal basis by which the trial court could make the declaration, the specific declaration that they're seeking in the amended complaint? And given the fact that there is no case that actually allows for that kind of declaration, we believe that the trial court absolutely was correct to follow Fairway Manor to find that the claim should be dismissed for failure to state a claim. We ask the court to affirm. Is there, unless there's any other questions, I'll conclude with that.
No,
Thank you.
Council, you have just under 2 minutes remaining.
I'd like to read the holding in Mount Sinai. And I emphasize again, if you read that case, it has nothing to do with any distinction between intra-territorial customers and extra-territorial customers. The holding in Mount Sinai says the only general restraints imposed upon the distribution of water are that the rates charged be reasonable, and that there be no unjust discrimination among customers served, taking into account their situation and classification. And obviously, Fairway Manor, there was a contract involved, and you have to adhere to the contract provisions which set forth rates. So that is not applicable to this situation. The text of the opinion in Fairway Manor, a lot of it is part of the holding of the court. But the dicta by Justice Douglas is a statement of opinion unrelated to the facts of the case or necessary to the holding of the case, which clearly was based on the contractual provisions between Summit County and the city of Akron. We did raise the issues that were in Amherst Builders and Home Builders of Dayton in the trial court. We raised them in our brief in opposition to the motion to dismiss, and we raised in our reply brief. We don't have to set forth the cases that we are relying upon in our complaint or our amended complaint. We set forth the standards that are in those cases in our amended complaint. You know, Akron seems to try to cloud the issues here when it comes to those arguments. We were arguing by analogy to the tap-in fee that was part of the Home Builders case, and the illegal tax, which was part of, well, the tap-in fee was the Amherst case, the legal tax or impact fee was the Dayton case. And we're arguing by analogy that this charge is similar to those types of charges, and the standard is that they have to have some reasonable relation to the services being provided.
And counsel, I need to inform you that you've utilized all 15 minutes of your allotted time for oral argument.
We would ask, based on my arguments and our briefs, that the court reverse the trial court and remand it back to trial on this matter.
Thank you. Thank you all for your presentations today. Court will take the matter under advisement. We will issue a written decision, which we mail to both sides, as well as posted on the Ohio Supreme Court website, which can be accessed through the 9th District website. Thank you. We are adjourned until next Tuesday.